Judgment. In this, we have taken into consideration the object with which 319 came into force, then taken note of Hardeep Singh and Shashikant Singh. Both we have said are not wrong. And since Hardeep Singh says that judgment, then we have tried to explain what is that, which is the period when which the trial comes to an end, judgment means. So there we have said, insofar as acquittal is concerned, this power should be exercised before acquittal order is concerned. And in cases where conviction is there, it is before sentence. And in any case, if it is on the same day, it has to be shown that this power was exercised before the sentence was. So in those circumstances, we have answered the questions, only those parts I'll just. The first question was whether the trial court has power under section 319 of CrPC for summoning additional accused when the trial with respect to other co-accused has ended and judgment of conviction rendered on the same date before pronouncing the summoning order. Answer to that is the power under section 319 of CrPC is to be invoked guidelines for the trial court that we need not read here. Having answered the questions referred in the above manner, we direct the registry to obtain orders from Honorable the Chief Justice and place before the appropriate bench to take a decision on the factual aspects arising in the case in the background of the legal position and contentions on merits. Before parting, we place on record our appreciation for the assistance rendered by all the learned senior counsel, including Sri S. Nagamuthu learned senior counsel, who assisted the court as an amicus curiae. Somebody else say.
ಚೆನ್ನಾಗಿ ಬಂದಿದೆ ಚೆನ್ನಾಗಿ
Agreed.
Lords could resume and make a small request minutes.
Yes, Mr. Naidu.
501.17 minutes. I represent the petition in this one, which is a cooperative bank, a district cooperative bank.
But now the grievance of the cooperative bank no more survive now.
Minutes, I am told, we have raised only a collateral issue. Perhaps I was told it's not been addressed because it could be detagged. The grievance is that minutes, when it comes to acceptance of these notes, we were given a cutoff date between 10 and 14. But what we got accumulated to turn of 15 crore rupees on 8, that's not been there. We have said it's arbitrary, that has to be looked into.
Take care of your interest also. If you want, you can address on that issue also.
So be it.
You can address your arguments. We will permit you to
Sure.
address.
That, Mr. Dewan has already argued that the power has to be considered as a power coupled with duty.
Duty. Under that subsection 2 of.
2 of 4. Subsection 2 of section 4.
This aspect is completely different. This is about banks depositing notes, not individuals.
No, that we will.
It's a different issue, Millard. There are different notifications.
He wants it to be detached.
Millard,
No,
Yeah.
detag means it has to go again before a 2 judge or 5 judge. 2 judges.
Millard, I'm told 9 such matters are not part of this batch. There is no order, perhaps, for reference for Constitution Bench. The issue, Millard, partly is
minutes.
1.
50.17.
Liquid, so and so and so. 3 so and so, learn a senior counsel appearing on behalf of the petitioner submits that the issue involved in this case is distinct, and that similar issues are pending before a 2-judge bench in 9 other cases.
I'm told minutes.
but I'm told it's 9.
All right.
Your Lordship didn't mention the figure, but there are matters pending, Millard, which are not before your Lordship.
Other 9 other cases which are so and so and so. You put a draft and give it. Therefore, this petition is detached and list this case along with the other cases pending before the 2-judge bench.
So Gupta, ask someone to give the number of those matters.
I will give. Well, that last appeared before Chief Justice
All right,
Lalit.
Shri Jaideep Gupta, learned senior counsel representing the RBI, is requested to furnish the other cases pending on this
Yes.
question, so that this case can be, and tag this case along with those cases.
Very well,
All
very
right.
well.
Chalo.
May I humbly submit?
Yes, yes.
I am waiting for my turn. I believe today London's AG will take time and other will not give it. So I hope tomorrow I will be given a chance to take this. one.
All right, sir. All right.
Oblige your lordship.
Yes, sir, there are some SLPs and transfer petitions and IAs which are related to question number 9, Your Lordship. So, Your Lordship, I believe Your Lordship is not detagging those matters because our matter should be heard here only, Your Lordship.
Right? And we are not deciding the case on merits, rather, on facts.
Your Lordship,
And you can go and you can argue later, no, whatever.
but question 9 should also be decided by this honorable right. Your Lordship. My humble submission is this only. Thereafter, we can go before other.
Then you can argue that question 9 also at a later point. Now that the AG is
Yes, I just got some confusion.
all right, you can argue, no issue.
That is like.
Well, if all the district cooperative bank matters go out, then that one question probably Your Lordship will not be answering in this.
So whether they are also referred, any question is referred on those.
One question on DCCB banks is referred.
Then let her address, then you can argue later.
Yes,
Let her.
not saying Your Lordship has to.
No, if that is also referred, then we will answer that question also.
Well,
Side that issued.
See, we don't know.
so if Your Lordship wants to keep that aside, then this question should not be answered by this circular. It can be answered later on.
There's so
Which
many.
question?
The question,
number
Lord, question number 9 of the
Whether they are
original question.
discriminated.
Whether the DCCBs have been discriminated or not.
That's it. All right.
There are so many other matters which are.
All right, there are many matters in the Supreme Court. There are 70,000 cases. There are 70,000 cases. All right, let us see. Let us make a beginning at least. There are 70,000 now.
You please, your lordship.
All right.
And I have
Yes,
a
sir.
additional note of submissions.
Yes.
What I propose to do is I'll take your lordship through this note. As I run through this note, I will address some of the questions which I did not answer on the last occasion regarding interpretation of section 26, etc. I will run through them. And thereafter, I don't propose to read in extenso judgments in support of my argument. I'm giving a list of them with a short, extract from the relevant judgments.
All right.
And then the 6-7 points of arguments relevant of advance. I've tried to prepare again a brief note in respect to each of the arguments so that will supplement my written note.
Yes.
And I'll conclude with that.
Yes, right.
Don't want to use our pen.
Yes, sir. Please proceed.
I think we should conserve your lordship's time and see as precisely as possible. I try to advance the
It's
argument.
very nice of you.
Yeah, really. Yes, sir. The first submission in my note is regarding the excessive delegation. And just quickly, headings I'll just quickly run through, and then your lordship turn to page 4. I look at the procedure under 26(2). Then we go to the interpretation of section 26 on the meaning of the words any, etc. Then page 10, I try to look at how when the Act has virtually incorporated the notification and refers to it in section 3, the notification has been affirmatively dealt with by the Parliament, and the notification does not exist as an independent instrument of law. And Parliament has applied its by notification. Therefore, what we'll be looking at is the parliamentary law and not the notification. Then at pages 11 to 13, we are looking at the dates, choice of dates, and why there is no arbitrariness in it. Then at page 14, I was trying to look at the proportionality test, why it is not applicable here. Then lastly, at pages 17 to 18, we say that an argument raised that the notification has failed to achieve the objectives. A very important argument. That a person with a rich experience about governance and finance and all that comes and makes an argument that you are chasing illusory objectives. I say this is not a ground on which a law or an instrument of law will be struck down. Something very strange has been advanced before the court, and a very responsible argument. So I would like to look at that. Kindly now come back to my page 1. Page 1, para 1.1.
Yes.
Section 26(0) does not constitute excessive delegation, cannot be prospectively overruled. There are two primary reasons why Section 26(2) cannot be considered as excessive
Mr.
delegation.
Attorney,
Yes.
Mr. Chidambaram has appeared as a counsel.
Your Lordship, is it?
Mr. Chidambaram has appeared as a learned counsel for the petitioner.
But he comes with him as a rich experience of being a finance minister. He may be a counsel.
The question would be, when the objective at the inception was valid, assuming that it is not achieved, would it invalidate the action?
Certainly not. Certainly not. I mean, the every minute of governance looks at targets. Or a 5-year plan have targets. And then over a period of time, the targets either met or not met for a number of reasons. Therefore, the targets become bad.
Yeah.
The last occasion that look at the benefits flowing over a period of time. And
Mr. Attorney, there is a challenge to 26(2) also.
I'll come to it immediately.
A twin challenge.
It is part of my written note.
First challenge that it has to be for any currency and not for all currency. And if it is not read down in that manner, then the section has to be held to be giving an excessive, uncanalized, arbitrary power, and therefore not valid in law.
I know. That's why I tried to put it in a,
Interpretation is one part.
Your Lordship.
Challenge is the other part. Interpretation of 2060 is one aspect.
Right.
Challenge to the 2062 as it is. So Mr. Chidambaram said it has to be read down.
My first response is, why should it be read down?
We don't know.
No, the arguments are it is uncanalized, unguided. Therefore, it violates certain constitutional provision. It should be read down to save it. Reading down is a device which courts have evolved to save a law or an instrument of law from being treated as invalid or unconstitutional.
Yes.
So the DTC Mazdoor case, the state of West Bengal, all those long line of cases reading down, you want to save the law. But when saving the law, you want to read something into the law, so the law survives. So if the anxiety is that 26(2) being uncanalized should be struck down, then why should we go beyond that and say let it be struck down? So there's a conflict in the arguments I'll try to propose.
Okay.
That's right.
All
Right. That's why I thought I'll read it and then it will be clear as I go forward.
Great.
And then I'm trying to point the last occasion, it is not that the targets have not been met. You have to look at it from a certain range of period and how they have merged into one another and how each target, income tax, PAN return, so on and so on and so forth. I've let all those details. So over a period of time, if it has ushered in a certain framework, the court will look at the larger framework and not look at what happened immediately after the next day of the notification. So on matters like this, you must have, according to the petitioners, you must have a standard. I'll bring that scale of standard and find out how quickly you achieve the targets, or how quickly you fail to achieve the targets. I say that's not possible in matters like this at all. The court will only look at the unfolding picture over a period of time. And if this withdrawal of legal tender is one important element to be introduced into it, don't look at it in isolation at all. But you want to look at it in isolation, then we have a different picture. Then every policy where a tool or an instrument is pressed into service, you will not look at the larger picture. You will only look at the tool or the instrument. You may have any number of objections to it. Right.
Yes.
Para 1.1. There are two primary reasons why Section 26(2) cannot be considered as excessive delegation. The first is that Section 3 of the RBI Act, which has neither been challenged nor even adverted to by the petitioner, grants or rather transfers the complete powers of the RBI for the purposes of taking over the management of the currency from the central government. The preamble also makes it clear that the RBI was created to regulate the issue of banknotes and the keeping of reserves with a view to securing monetary stability in India and generally to operate the currency and credit system of the country. RBI is not just like any other statutory body created by an act of legislature. It's a creature, creates a mandate to get liberated even from its creator. Then taking over the management, that's footnote 1, the largest cryptocurrency judgment, well, the Ramsman will get it in greater detail. And taking over the management of currency and regulator words of the widest import, and no rules of interpretation would support a narrow interpretation. It is said that the power to regulate something is wide and includes the power to prohibit. Any restrictive interpretation of these provisions, Section 26, would do violence to the very intent and scope of the RBI Act. The second is that the transfer of such powers is not delegation of power, as is understood in the context of delegated legislation. Just passing here for a minute. Ordinarily, you look at a rule-making power given to under the Act or a power to exempt. These are by and large situations when a delegate legislation comes into question. This is not one such case at all. I'll try to point out. And therefore cannot be tested on the parameters thereof. What is taking place by virtue of Section 3 of the Act, read with the other provision therein, is the transplanting of the primary responsibility of currency management in the country from the domain of the Union Executive to an expert body, the RBI, which acts through its board, set up exclusively for this purpose. It is not the case that Section 26 empowers a further authority or a delegate to exercise its powers. The transfer of powers of management of currency by itself or any part thereof cannot suffer the vice of excessive delegation. Now, those provisions I've set out here, preamble and regulate, Section 3 taking over, Section 17 (15) making and issue of banknotes subject to the provision, 22, right to banknote. 23, denomination. 26, legal tender. I read all those provisions in the last occasion. Next. The RBI is specifically empowered to do certain things to the exclusion of even the central government. Therefore, to place its decisions on a pedestal lower than that of an even executive decision would do violence to the scheme of the Act. Then that is again the internet judgment will throw some light. The inescapable conclusion to be drawn from a combined reading of the provision is that the power of RBI with respect to the management and regulation of currency is complete and not capable of being circumscribed without severely affecting the working of the Act itself in its current form. Very important. Anything with section 26, you're probably dealing with the spine of the legislation. So let it be an erect spine, not a spaghetti spine. Therefore, without challenge to a section 3 that's overly wide, there can be no challenge to other provisions of the RBI Act, which are in furtherance or other specific instances, kinds of such regulation management. Court will not lightly therefore interfere with economic legislation, particularly in the context of RBI, as the interdiction will have wide-ranging consequences. Then, as regards the second limb, when seen in the above conspectus, it cannot be argued that Section 3 suffers from the vice of excessive delegation. I'll just quickly run through the few of these judgments. As laid down succinctly in Municipal Corporation of Delhi versus so and so, under the Constitution, the legislature has the plenary powers within the allotted field. Essential legislative function cannot be delegated by the legislature. That is, there can be no abdication of legislative function or authority by complete effacement or even partially in respect to a particular topic, a matter entrusted by the Constitution to the legislature. Power to make subsidiary or ancillary legislation may, however, be entrusted by the legislature to another body of its choice, provided there is enunciation of policy, principle, or standards, either expressly or by implication for the guidance of the delegate in that behalf. Entrustment of power without guidance amounts to excessive delegation of legislative authority. Mere authority to legislate on a particular topic does not confer authority to delegate the power to legislate on a topic to another body. The power conferred upon the legislature on topic is specifically into the body, and it is necessary intendment of the constitutional provision which confer that power. It shall not be delegated to living into principles, policies, standard, or guidance on another body unless the Constitution explicitly permits delegation. Further, this case is also held what guidance should be given and to what extent, and whether guidance has been given in a particular case at all depends on a consideration of the provisions of the particular act with the court deal, including its preamble. Further, it appears to us that the nature of the body to be delegation made is also a factor. The body to be delegation made is also a factor to be taken into consideration. We'll have any number of instances where an administrator under a statute or a collector, somebody is given authority to do something, fix a rent regarding a rent fixation, or exempt a body from the application of the act. Look at the level of those persons. We are talking about RBI. Therefore, a factor which will be taken into account is who is the person who is entrusted with the body, to discharge functions under the act. And 1.5. These principles may be applied to the RBI Act. First, as held by this court, the RBI is not a mere statutory authority. It has the mandate to liberate even from the creator, and its decisions cannot be placed at a level even below the executive decision. This itself militates against the possibility of the functions and actions of the RBI and the RBI Act as being delegated. Second, the RBI itself is the sole authority managing the currency of the country. There is no question of it being delegated essential legislative functions. Consequently, questions of guidance from the legislator or the executive for exercising the functions by RBI also cannot arise. And finally, as stated earlier, it is not a case of the RBI delegating its functions in any manner to any other body or authority which would invite the application of the opposite principles.
Attorney, I feel that their argument is that there is an excessive delegation to the central government.
Central government acts on the recommendations of the RBI. Acts on the recommendations of the RBI.
And I think they don't have any quarrel with your proposition that the RBI has supremacy. So their argument is that the RBI has supremacy and therefore the proposal ought to have emanated from RBI.
I'll address that argument very soon. I look at section 26, I tried to point on the last occasion. It's a very unique provision. You're looking at the management of currency and declaration of certain instruments as legal tender. and withdrawing them from legal tender, right? In this, is it possible to suggest that RBI will act in an isolation or the government will act in isolation? So I tried to tell your lordship that both the RBI and the government in an important monetary policy of the country where section 26 aids both of them. It's a source of inspiration, acting for both of them. So in that context, there is no question of delegation to either the government or the RBI. They act in consultation, recommendation from RBI.
They have to act together.
That's right. Consultation need not be necessarily expressly stated in the provision. It is the lifeblood of the whole act. Therefore, to say that the law should have said government will act in consultation, the consultation with the following parameters, you will write down everything about consultation, draw your minutes of consultation. No, not necessary at all. Your lordship knows in the context of Chief Justice recommendation.
Debate on consultation.
So in the context of Chief Justice recommendation, consultation, you're going to exercise consultation, concurrence, we try to equate them, consultation, a very flexible principle. But the flexibility of an instrument of law, given the functions it has to discharge, that will be kept in mind.
If you have considered that argument in subsequent paragraphs, go on.
Distinguishing cases cited with the petition in relation to excessive delegation. In this case, the impugned provision related to an administrator designated in the Gold Control Act of relevance in determining the issues was that there were provisions parallel to those of the administrator, which require the rules made under the Act to be placed before the Parliament. In this context, the court held the powers granted to the administrator were too wide and suffered from excessive delegation. So two things. One, the administrator and not the RBI. So look at the difference, the level, the status, the function.
The nature of the body.
Right. This is not the position so far as section 26 is concerned. There is no further delegate, etc. with discretion with respect to powers under 26. Then Hamza Dawakanas. In this case, the power to make rules designate specific diseases or conditions in the schedule. The Drug and Magic Remedies of Adjustment Act 1954 was under challenge. On the ground that there are no parameters laid down on the basis of which any disease or condition to be added there too. No parallel may be drawn here too. The designation of diseases or conditions to be covered by the statute has to be done on a scientific, determinable base of criteria, absent which it could ostensibly be arbitrary. However, it is impossible for the legislature to prescribe all or even an indicative set of reasons or circumstances under which the banknotes can ought to be demonetized. Doing so would cripple the powers contemplated by Section 3 and severely restrict the ability of the RBI to manage currency. Next. The procedure laid down under Section 26 was followed in the present case. The scheme of Section 26(2), providing for an interaction between RBI and the central government, must be seen a very special policy perspective. The use of the word recommendation deserves to be seen in the context of the integrated role that we played by RBI and the central government acting together in promotion of public interest. The word recommendation must therefore receive a flexible approach, since the subject matter of legal tender and the cessation of banknotes as legal tender are not matters that can be dealt with merely and exclusively by RBI. It is sufficient for the purpose of Section 26(2) that emanating from a consultative process between RBI and the central government, a proposal issues out from the RBI. It is inappropriate to suggest that matters of policy relating to the three objectives, purposes set out in the notification dated so-and-so must come as a measure of recommendation from the RBI. It's sufficient that RBI plays its facilitating role by discharging the measure of making a proposal to the central government. That's what has happened here. It would be naive and a matter of serious economic fallacy to suggest concerns such as terror financing, black money, and fake currency need not be seen as touching upon or impacting the subject of cessation of banknotes as legal tender and vice versa. Consequently, the idea of recommendation in Section 26(2) will fundamentally vary from its dictionary meaning or its occurrence in any other legislation. Next.
If your 1 second, Mr. Attorney General, if your argument is that the consultative process must be there, and therefore it is all right for the central government to initiate this measure and then submit the proposal to the RBI in consonance with the central government proposal, what happens?
The two in 1990
They brush aside the
in 19
recommendation.
in 19 provided, let me answer from a policy perspective again. Then we are looking at a hypothetical case for the purpose of construing Section 26. What happened in 1996, Jayanti Lal? What happened? It happened, the Parliament wanted to do the law. RBI did not play any role at all. This court said there's a valid law.
No, we are not on that. We are testing your
I know, I'm
argument.
trying. Therefore, there can be instance when Parliament wishes to act. RBI may have a point of view, but the Parliament can certainly say, I don't agree with you.
Inside the Parliament, because here it is not by an act of Parliament, is not envisaged under the section.
I'll come to it.
What's envisaged is notification in the Gazette of India.
Correct.
Therefore, if Parliament did it on those two occasions, it is the wisdom of the Parliament. But that is not a mandate under 26(2) that it has
Certainly not.
by Parliament.
Certainly not. but
But
you know,
suppose it emanates from the central government and the RBI, in its wisdom, thinks that it is not the right thing to do right now or not the right thing to do at all and gives its proposals to the central government. What happens then?
No,
Will the central government brush it aside?
The answer will come in a given case where we have those differing perspectives.
No, we are saying...
No. In a case... Facts. Then the court will find out whether the difference in perspective, whether the ruling out, the central government saying, I don't agree with you, then the court will probably look into it at the preliminary level. Just allow me to develop.
Bound by the recommendation.
Just allow me to develop the point.
Yes.
So therefore, the central government need not necessarily be bound in a case where it has a disagreement with the RBI. Then what's the role for the central government? Would the central government do an issue notification? Moot questions. But here in this case, as what happened later, the notification has now merged with the Act of Parliament. 2017 Act says, I refer to the notification. Therefore, that question of disagreement, what will the central government do, etc., may not be necessarily arise in this case.
No, we are testing your argument.
I know, I'm right. I'm only trying to say then it does not arise in this case. But in a case where it arises, it must be in the context of a fact. In that context of a fact, the court may find out whether there are, again, maybe that's a moot point. The court may decline to go in that question. The court may say, well, yes, government may, in its policy perspective, not as a delegate, as a sovereign power, even though government is as a statutory authority under the Act. But government acting as a sovereign power can still disagree with the view taken by RBI. But we don't have to get into a speculative question of whether it can happen or not for the purpose of answering this case.
No, for the purpose of interpreting.
Quite right. I'm not saying that's quite right. That's a very important question. But it may arise in a case where the fact situation would warrant an inquiry into that nature. Where a fact situation does not warrant, perhaps this question will be a moot question. Kindly let me allow to go further. Para 2.3. The recommendation by RBI will therefore not be subjected to strict or close judicial scrutiny. Given the scheme of the Reserve Bank of India Act 1934 and the amendments made to the preamble thereto, it must be taken that RBI is just not any other expert body, but a very special institution charged with the duty of conceiving and implementing various facets of monetary policy. In the discharge of the duty, there cannot be any straightjacket formula. The nature and wisdom of the decisions taken within the framework of the scheme of RBI Act and its signposts and roadmaps set out in the preamble will always deserve deference. In keeping with the above understanding of the scheme of Section 26(2), it is submitted the proviso carries sufficient safeguards that can be gathered from the various provisions of the RBI Act, including the preamble. The suggestion that Section 26(2) is an impermissible delegation of legislative power and misconceived is also not in consonance with the law declared by the Honorable Court. In similar situations where the opinions or recommendations of an expert body or set of experts are concerned, the Honorable Court has repeatedly stated it will not sit in appeal over the decision and leave it to the experts who are familiar with the problems they face. Even more so in the case of economic policy decisions obtained by the Honorable Court in Bajaj Hindustan Limited, so and so. Economic and fiscal regulatory measures are a field but judges should encroach upon very warily, as judges are not experts in this matter. The improved policy parameters were fixed by experts in the central government, and it is not ordinarily open to this court to sit and appeal over the decisions of the experts. We have not been shown a violation of law in the review notification or a press note. It is submitted there are no compelling reason or constitutional grounds for persuading the Honorable Court to enter into the scheme of Section 26(2), its dissection, or advising on the exercise of the respective powers conferred on the central government and the RBI. It is submitted there are no flaws in the decision-making process, keeping in mind the daunting task of addressing the three challenges referred to in the notification. Difficulty is an issue that might have arisen in the course of giving effect to the notification, and the 2017 Act cannot be said to be flaws affecting the decision-making process. The evidence-based reasonableness or any such corresponding principle may not be of strict relevance. The very idea of entering into reasonableness of the need to address the three factors and their impact on the economic system of the country is open to debate. The three factors are terror financing, fake currency, and black money. I repeat, the very idea of entering into the reasonableness of the need to address the three factors and their impact on the economic system of the country is open to debate. The subjects of black money, fake currency, and terror financing are being studied over a period of time, and information and data gathered from various agencies of the Government of India are available. The 2012 white paper on black money throws light on the complexity of the problem. It would be naive to suggest that the government does not update itself on the above issues, which forever threaten or affect the economic stability and the currency management. It's further naive to suggest that there should be a need for a detailed survey and a study having regard to the enormous impact on citizens' rights by the decision if need to be taken on above issues. From the accounts of hardships that have happened, it cannot be canvassed the Union of India did not apply its mind and was not guided by a study. Next, the proper construction in a series. Section 26.2. Before I take a lordship, I just want to read one judgment of the US Supreme Court. Just I read over. The lordship may come back to page 5 where I was referring to Bajaj Hindustan. The classification of the ordinance. I'm sorry. The attack of the complainant is upon the classification of the ordinance. It is contended that the purpose of the ordinance is to raise revenue, and the classification of the relation surplus, and therefore is arbitrarily discriminatory and thereby affect the 14th Amendment of the Constitution of the United States. The character ascribed to the ordinance by the Supreme Court of the state is not without any uncertainty. But we assume, as complainants said, that the court considered the ordinance the revenue measure only. The court said the ordinance will be sustainable under taxing power alone, with a reference to reasonableness as a regulatory measure. Regarding it as a revenue measure, complaints attack is unreasonable in basing its classification upon the price of admission of a particular theatre and not upon the revenue derived from therefrom. And to exhibit the discrimination which is asserted to result, a comparison is made between the seating capacity of complaint theatre and the number of their performances that are giving within a given period and the theatres of others in the same respect and resulting revenue. But these are accidental circumstances and dependent, as the Supreme Court of the state said, upon the advantages of the particular theatre or choice of its owner and not determined by the ordinance. It will but immediately occur upon the most causal reflection. The distinction of the theatre itself makes it is not artificial and must have some relation to the success and ultimate proof of business. In other words, there is a natural relation between the price of distinction, price of admission revenue, some advantage certainly, that determines the choice. The distinction obtained in every large city of the country. The reason for it must therefore be substantial. And it is so universal in the practice of the business to scheme, government not unreasonable if it to be adopted as the basis of governmental action. If the action of government have such a basis, it cannot be declared to be so palpably arbitrary as to be referred under the 14th Amendment. This is the test of its validity, as we have so many times said. We need not cite the cases. It is enough to say that we have tried, so far as the amendment is concerned, to declare in words, and the cases illustrate, for example, the wide range which legislation has in classifying as object. To be able to find fault with the law is not to demonstrate its invalidity. It may seem unjust and oppressive, yet be free from judicial interference. The problems of government are practical ones and may justify if they do not require a rough accommodation, illogical it may be, and unscientific. But even such criticism should not be hastily expressed. What is best is always not discernible. The wisdom of any choice may be disputed or condemned. Mere errors of government are not subject to our judicial review. It is only so palpably arbitrary exercises that can be declared void in the 14th Amendment. Now let me proceed further. And
you would have required 100 pages to write it. Come on, bro. Come on, bro.
I 26(2). Any unguided, uncanalized, and arbitrary power in the executive. It is fallacious to read section 26(2) in isolation. It's further fallacious to close one's eyes to the very intrinsic dynamic scope of a provision of section 26(2) in the context of managing monetary and financial policies of the state. Section 26(2) cannot also be seen as a mere demonetization measure without reference to any number of factors, aspects, and challenging confrontations affecting the economic system of the country and its stability. The comparison with the 1946 and 1978 legislation is superficial and misconceived. In the case of both the said legislation, recourse to section 26(2) was not undertaken. Parliament intended to act swiftly and on the need to act so. As is submitted here and below, the 2017 Act rightly addresses the issues relating to cessation of legal tender, provisions for exchange of banknotes in order that Article 300A is complied with, and also the question of the liability of RBI under Section 34 of the Act. The petitioners have laid emphasis on the language of Section 26(2) insofar as it only permits cessation of legal tender for any series of banknotes of any denomination, with the interpreter to exclude a situation where all series of banknotes of particular denomination are demonetized in one go. It is a well-settled principle that courts will strongly lean against the construction of a provision which will reduce it to a futility. The following statement of law is also equally well settled. If the choice is between two interpretations, the narrower of which would fail to achieve the manifest purpose of the legislation, we should avoid a construction which would reduce the legislation to futility and should rather accept the bolder construction based on the view that Parliament would legislate only for the purpose of bringing about an effective result. An effective result, very important. The word any preceding, the word series, must therefore receive such construction that will effectuate the policy of section 26(2). At any given point of time, there will be several series of banknotes relating to a specific denomination or all denominations. The object of enforcing cessation of legal tender will therefore necessarily address the denominations in questions to be dealt with. It will always be a matter of great sensitive policy decision-making for the government to tackle matters such as terror financing, black money, and fake currency for the purpose of ensuring stability and integrity of the monetary system and its connection with and contribution to the economic well-being of the country. Once the government decides on the number of denominations to be dealt with, the policy perspective will dictate the number of series to be reckoned. Given the free play in the joins conceived in section 26(2), the word any preceding the word series must receive purposive interpretation. In this regard, it's worth noting that the word any is commonly interpreted to include all. In fact, even in legal parlance, it's been held that any can very well be used to indicate all. If the word any has just been read to mean all in varied circumstances, obviously, depending upon the context, it must necessarily mean all under section 26(2) in order that such a special provision in a special legislation is enabled to fulfill very important policy needs built into the scheme of section 26. As already submitted, the focus under section 26(2) will be on denomination, vis-a-vis the volume and quantum of circulation of the denomination, and the need to deal with the denomination for the purpose of addressing the three factors, namely terror financing, black money, and fake currency. It will therefore be futile to suggest that only particular series of denomination must be picked up. Consequently, the question of reading down any series to mean particular series cannot arise. The invocation of the principle of reading down is therefore misconceived. The law in regard to reading down does not envisage its application to provisions such as section 26(2). Even as a practical matter, the petitioner's argument cannot be accepted insofar as it leads to an anomalous situation wherein the government would technically be permitted to issue separate notification for each series, but will be prohibited from issuing a common notification for all series. The former course of action would in fact likely lead to chaos and uncertainty, whereas the later course of action would likely negate any such concerns. The word any would also mean all, depending upon the context. Then we have these judgments, 1962 Chief Inspector of Mines. Any one of the directors in section so and so means only one of the directors or every one of the directors. Then Banwarilal, any one and section so and so interpreted every one. Then the next one, in action seeking damages for defamatory statements given by the members of the Parliament, while interpreting Article 1052 of the Constitution of India, it was held that anything is the widest import and equivalent to everything. In the LDA, next, in Section 2O, Consumer Protection Act, service of any description was held to mean one to all, from one to all. The next, in CIT, any case in the Section 127 of the Income Tax Act was held to mean all. Then next one, any order or decision of the appellate tribunal was held to mean all. So any number of we can multiply the instances, and I'll give a few more. Then para 2.4.11, a word more than once in a section can have different meaning. Section 26.2 uses the word any twice. However, the meaning of any would be different in view of the context in which the word is used in section 26.2. The first use of the word any would mean all, but the second would use the word any or to be singular, or thus the central government can exercise its power under section 26 to declare any or all series of a given denomination to cease to be legal tender. So when you say any denomination, the government will find out what are the denominations which are broadly relatable to all those three factors, or currency management. So it pick up 500,000, 2,000, or maybe all, may only a few. Therefore, the dynamics of interpretation of the word any in relation to series may not be the same thing as you talk about any denomination. So such denomination which would address the question to be tackled with. Therefore, that's how the section 26 will have to be interpreted. I've given few instances here, and now kindly. Hand it over to your lordship. I don't propose to read them. This is the quote. Good, Master. I'm so there's a small pencil mark note here. Your lordship may kindly ignore that. Series of banknotes, working definition. A series, though not defined explicitly, ordinarily refers to the banknotes with common series. Thus, a number of series cannot be termed as a banknote series. Then, third, mere addition of one or two features, example, rupee symbol, bleed lines, etc., is not considered as a new series. A change in series is typically characterized by significant change in disalignment, security features. A change in series ordinarily spans multiple denominations. For example, 2005 MG series was introduced with set of additional security features, latent ways, etc. And MG series issued in 1996 did not have a security feature. Whether multiple issues of banknotes takes place in a series. Multiple issues of banknotes can take place in a particular series over the period, for instance, due to change in governor, year of printing, minor features, etc. Further, the volume and the value of banknotes to be printed and also its subsequent issuance in a year depends on various factors such as the expected increase in notes in circulation to meet the growing needs of the public. The need for replacing soiled, mutilated notes was to ensure that only good quality notes are in circulation. The expected increase in NIC estimate using statistical methods, which features production and supply of banknotes. The preamble mentioned, whereas so on. So logically, just skip that and come to last sheet. The chronology of series is given here from 1949. So we had other series which are in circulation. So for instance, in 1967, we had the Mahatma Gandhi Centenary Series. In 87, you added Ashoka pillar as a watermark. So features are added. Then 96, the MG series again with the portrait and the watermark. For our purposes, in 2005 and 2016-17, the new series, the enhanced security features. So we were looking at, and the notification talked about the existing series, which means all series with a reference to denomination chosen for declaration and cessation of legal tender will be relevant for the purpose of proceeding under Section 26. To say that, therefore, existing series was incorrect in a way of looking at it, you could have picked up a series of 96, a series of 2005, a series of 2015, would be to essentially curtail the width and the plenary width of the decision-making process on the basis of consultation between the government and the RBI. For any must mean all, and it must be as flexible as possible. Then para 2.5 at page 10. The 2016 notification has been incorporated by reference in the 2017 Act. The key argument advanced by the petitioners is that powers under Section 26(2) ought to have been exercised only by the Parliament after due deliberation. In this regard, it is worth reiterating that his line of reasoning proceeds on a complete misconception about the nature of the powers exercisable under Section 26(2). In fact, even a plain reading of the section, it is evident that it explicitly grants power to the executive to issue a notification for the purpose of withdrawing the legal tender status of certain banknotes, and there is no requirement for the Parliament to be involved in exercise in any manner whatsoever. As already mentioned previously, the fact that the 1946 and 78 legislation as already mentioned previously, the fact that the 1946 and 1978 demonetisation legislation were passed by the Parliament does not in any manner contradict this position, since those legislation were passed independently and not in exercise of the powers under Section 26(2), a fact that is amply borne out by the presence of the non-obstante clause of Section 3 of both those legislations. I'll currently invite Lord's attention to the 1946 and 19. Yeah. I'll just invite lot to the paper book. The section 3 is similarly worded, and we'll give this 78 Act. Stations and ordinances, a small thick volume relation. That 1946, that's probably the last, third in the serial. Section 3 of the 46th Act. Separate copy. It is also there. There you are. Page 4. Here it is there in that. Can kindly turn that page where section 3 of the 46th Act is available. May I read it? On the expiry of the 12th day of January 1946, all high denomination banknotes shall, notwithstanding anything contained in section 26 of the Reserve Bank of India, cease to be legal tender. So it refers to section 26, notwithstanding what RBI and government can do under 26, notwithstanding that, I am doing as Parliament in its plenary powers. The same provision, similar provision is in 1978 legislation. If you should now kindly come to the 2017 Act, which is also there.
That is, or we read it, the Parliament is. That's why.
Page 10.
The 2017 Act is also in the same.
Page 10.
That's right. And in the 2017 Act, Section 3 is has taken a different form. Can you read that? On and from the appointed day, notwithstanding anything contained in the Reserve Bank, notwithstanding anything contained in the Reserve Bank of India Act 1934. Because there's a reason why it has been expressed like this. Or any other law for the time being in force, the specific banknotes which have ceased to be legal tender, in view of the notification of the Government of India so and so, issued under so and so Act, shall cease to be liability to the Reserve Bank under Section 34, and shall cease to have the guarantee of the central government under subsection 1 of Section 26 of the said Act. So it's a complete legislation by itself. So in the earlier situations when RBI did not give a recommendation in Section 26, there was no proceedings under Section 26. The government could have proceeded under Section 26. Parliament said, no, I am going to enact a law. So there is no deter as far as my power, plenary power of Parliament. Section 23, I'm keeping aside time being, and I'm enacting a law. Here we have a situation where a Section 26 power has been exercised. And the Parliament takes note of the exercise of that power. It also looks into the question of whether the liability of the bank will cease, Section 34 of the RBI Act. Therefore, it addresses all those connected questions. So it's not merely a question of mere talking about Section 26. In the entirety of the RBI Act, if there are any issues that may come in the way of Parliament addressing this question, why Parliament has to do this? It says in view of the notification of the Government of India. Like any other legislation by incorporation and reference, you also know that. So here is a reference to a notification issued by under a statutory power. Parliament says, I'm looking at it, I've considered that. I also look at the RBI Act as a whole. So I wish that this notification receives my affirmation. And Parliament says so. Therefore, that's an important distinction between the 4678 and this law. If the story has ended only with a notification, probably would have different issues and arguments being raised before the court. The story has not ended there. Therefore, in my very humble submission, the question of going back to the notification, looking at those infirmities, if any, those false and illusory objectives you are pursuing, you can say false and illusory objective being pursued by an executive authority. Parliament, you are saying now Parliament is pursuing an illusory and false objectives. Therefore, the story does not end with the notification. It merges into the law, parliamentary law, and whatever argument that we address regarding constitutional validity will have to be addressed against the parliamentary legislation. And a very unique piece of legislation, where Parliament gives a stamp of approval to a statutory exercise of power. Paragraph 16. Page 10. Yeah. I was reading at page 11.
5.3.
Your Lordship, please. Nevertheless, the submissions advanced by the petitioners carry no weight insofar as they fail to appreciate that even in the present case, the government exercise of powers so has been incorporated by reference therefore the same as effectively invalidated an act of Parliament. The notification dated 8/11/2016 has been affirmatively referred to in Section 3 of the 2017 Act. By such affirmation, Parliament can be said to have taken into account the notification and the implementation scheme. As a result, in the notification word in the parliamentary law, it has ceased to exist as an independent legal instrument. It will be taken that regardless of any issues relating to the exercise of power under Section 26(2), the decision to withdraw existing series of certain denominations from legal tender must be treated as a parliamentary plenary declaration. Then, next, the exercise of power under Section 26(2) was not arbitrary and unreasonable. When judicial review, the cutoff date is not permissible. One of the grounds on which the petitioners have sought to assail the 2016 notification is that the cutoff date specified therein was arbitrary. The total period given for exchanging of banknotes was too short and many individuals suffered hardship. Why I wanted to answer this, because even though the argument that once Parliament has said all that, court need not get into the question, I thought as a matter of responding to the submission, they must be addressed and probably some clarity brought to the court. Now, next, similar arguments are regularly made in other instances where a cutoff date is specified for a particular purpose. For instance, in the case of grant of retirement benefits such as pension, receipt of applications for appointment to a position, levy of a particular rate of excise duty, eligibility for a particular scheme, etc. In all such cases, the Honorable Court has repeatedly clarified that it will not undertake a review of the date specified or hold the same to be arbitrary unless it is shown that the fixation of that particular date is capricious or whimsical or wide of the reasonable mark. In this regard, as further opined in Parameshwaran Matchworks, have you no doubt that any date chosen for the purpose would be, to a certain extent, be arbitrary, that is inevitable. The choice of a date as a basis for a classification cannot always be dubbed as arbitrary, even if no particular reason is forthcoming for the choice unless it is shown to be capricious, whimsical in the circumstances. When it is seen that a line or a point, there must be, and there is no mathematical or logical way of fixing it precisely, the decision of the legislature, the delegate, must be accepted unless we can say it's very wide of the reasonable mark. And why it says so wide of the reasonable mark? There can be cases where a doubt may arise whether the date could have been something else. But in a matter like this, one can probably visualize, I must set sail on a navigating on a river, and I do not know when I will reach my destination. I will fix a cutoff date when I know finally I've reached my destination. Therefore, I must provide for all possible permutations and combinations for people who will be affected in some way or the other, who may lose an opportunity of getting the notes exchanged or the other. Therefore, I must have all that possible 100 million permutations and computation. I mean, is it possible in a matter like that? Therefore, to ask the court to say that I went abroad, I had my dignity to be protected. Of course, millions of people traveled across the globe. He went abroad on 4th of April in 2016. He probably won't have a benefit of being an NRI. People have had the benefit of being an NRI. So you choose to have a benefit of NRI on the one hand and say, look here, my dignity is being affected. So the government must sit back and see what number of people are going abroad, whether they are NRIs, whether other Indians going for being with their family or for other purposes, and when will they come back? So how do you take this kind of a decision? Therefore, it's impossible in a matter of this national magnitude, where certainly some acts will fall somewhere. I'm not saying that the hardship is to be completely ignored. That's not an argument. Hardships will inevitably happen. I'm not closing my eyes to that at all. The government also did not close its eyes to it. Therefore, if you see from 8th of November till early January, several modifications, amendments, insertions went on happening in the notification. So by the time it all got settled, the law came. The law had a clarity about at that point of time. Para 3.1.4. As such, in all instances of fixation of a particular date, it stands to reason there will be persons on both sides of the said line, and those who are left out will be agreed by their exclusion. As long as the exclusion is not deliberate or discriminatory, the court will not test the validity of a cut date. Cutoff date cannot be altered, modified, or extended to accommodate all possible exclusions. Administrative decisions based on the larger public interest or public convenience will not be altered on the basis of the interest of some person or an inchoate class of them. A similar argument raised in the context of the high denomination banknotes was struck down by a 5-judge bench honorable court holding. It is however contended on behalf of the petitioner that even if it was assumed that Article 31 had not been violated, the time prescribed for exchange of the high denomination banknotes in Section 7 and 8 of the Demonetisation Act is unreasonable and violates the fundamental rights. When the above provisions of the Act are considered in the context of the purpose of the Demonetisation Act sought to achieve, namely to stop circulation of high denomination banknotes as early as possible, the above contention of the petitioners cannot be accepted. Consequent upon the high denomination banknotes ceasing to be legal tender on the expiry of January 16, 1978, and in view of the prohibition in the transfer of possession of such notes from one person to another, thereafter the envisaged in Section 4, it is absolutely necessary to ensure that no opportunity was available to the holders of high denomination banknotes to transfer the same to the possession of others. At the same time, it was necessary to afford a reasonable opportunity to the holders of such notes to get the same exchange. However, if the time for such exchange was not limited, the high denomination banknotes could be circulated and transferred without the knowledge of the authorities concerned from one person to another, and any such transferee could walk into the bank on any day thereafter and demand exchange of his notes. In that case, it would have been well nigh impossible for the bank to prove that such a person was not the owner or holder of the notes on January 16, 1978. That's the question which will confront the bank, the RBI, under Section 4.2. Needless to say, in such an eventuality, the very object in the Demonetisation Act sought to achieve would have been defeated. Obviously, to strike a balance between these competing and disparate consideration that Section 7.2 of the Demonetisation Act limited the time to exchange the notes till January 19, 1978. However, even thereafter, in view of Section 8, the high denomination banknotes could be exchanged from so-and-so, provided the tenderer was able to explain the reasons for his failure to apply for the exchange within the time stipulated in Section 2 of the Act. Such being the scheme of the Act regarding exchange of high denomination banknotes, cannot be said that the time and the manner in which the high denomination banknotes could be exchanged were unreasonable, unjust, and violative of the petitioner's fundamental rights. I say with all my humility that the Constitution, when correctly understood, that the flexibility required cannot be brought within any parameters. That's why I kept on saying it cannot be cribbed, capped, and confined. Next, the test of proportionality cannot be pressed into service. The proportionality test is essentially the test of reasonable. The means adopted for the implementation of the decision must be means relevant for the object sought to be achieved. The relevance of the means will be dictated by the nature of the object to be achieved. It may not always be the case that the object can be achieved by more than one set of means. In the instant case, currency management is the object that the RBI will always continue to pursue and handle. Issuance of banknotes as legal tender and declaration of banknotes ceasing to be legal tender only means conceived under Section 26 for the purpose of currency management. Choice of mean, therefore, does not arise. The reliance in so-and-so case for the purpose of invoking proportionality is misconceived. On the issue of challenge to the mandatory linking of bank accounts with Aadhaar, what was found objectionable was the presumption of criminality targeting every citizen of the country. And therefore, there cannot be a mandatory provision for linking of every bank account with Aadhaar for the purpose of checking the possible malice of money laundering. In the instant case, the choice of denomination was dictated by reason of the fact that the two denominations chosen are the largest denominations in circulation and are the ones which are involved vis-a-vis black money, fake currency, and terror financing. The question of identifying currency involved above three does not arise. It would be conceptually wrong to suggest that if there are difficulties in such identification, then Section 26 should not be pressed into service at all. The fourfold test involved in proportionality cannot therefore be logically pressed into service. Let me try to answer each one of them. The fourfold test is answered under. First test is designated for a proper purpose. Answer. Currency management and monetary policy will always remain a designated purpose of high importance. All means and measures that will be found necessary from time to time to ensure the integrity and stability of currency management will also remain a purpose of importance. There can be hardly any debate on the importance of the purpose which is legitimately enacted in the scheme of the RBI Act 1934. Then, two, measures are undertaken to effectuate that the limitation are racially connected to the fulfillment of the purpose. Answer. Declaration of banknotes as legal tender and their cessation, which should not be, and their cessation as legal tender are the means designed to handle the currency management. It cannot be said currency management can be handled through other measures or without the principle of banknotes as legal tender. Additionally, the question is not one of imposing any limitation on the currency management, nor of effectuating the limitation. The limitation issue comes in when rights are sought to be infringed. There is no question of limitation of the powers of the RBI at all. Now, three, there are no alternative less invasive measures. The three evils sought to be addressed, namely black money, fake currency, and terror finance, breed on paper currencies precisely because the paper currencies of certain denominations are conducive to aid such activities. The question as to whether government should explore non-currency management measures as better or wise choices for the purpose of addressing these evils is not a matter for the court, nor a subject of judicial review. The government is duty-bound to address these evils if necessary by resort to currency management purpose and the tool of Section 26(2). 4. There is a proper relation between the importance of achieving the aim and the importance of limiting the right. This limb of the test, when it involves commensurating incommensurables, that is comparing unequals, commensurating incommensurables, it will break down. The importance of addressing the three evils referred to above cannot be compared with the importance of causing least impact on the use of legal tender. If the government were to search for the magic measures of causing least impact and wait till such time, the object of addressing these evils can possibly never be undertaken. Since legal tender, cessation of legal tender, paper currency management, exploitation and abuse of legal tender are all inextricably linked, and there is hardly any room for applying the above limb of the test with carefully chosen precision and degree. The wide range of instances involving application of the fourfold test of proportionality or otherwise will demonstrate that either within the statutory framework or within the scope of possible legal means for achieving a purpose, there has been misconceptions or failures as regards the means chosen, the extent of the sweep of the means chosen, or the failure to redress the impact of the means chosen means. It is submitted, we are talking about 86.4%, repeatedly is being thought about. So it is submitted that the suggestion for adoption of proportionality without rigorous scrutiny of its application can lead to open-ended moral or political reasoning, and the persuasion to engage in open-ended moral or political reasoning will always be avoided. Courts are conscious of the fact that the complexity of economic regulation always involves dealing with complex set of factors, the scope for error, experimentation, conflict of opinions among experts, and other similar factors. And therefore, courts grant the legislature and the executive greater latitude and play in the joint in matters necessarily involving interplay between principles, facts, and policy. So Section 26, this law, this notification is an example of interplay between principle, facts, and policy. 3.2.7. Accordingly, judicial review of economic policy ought to be restricted to the nexus test wherein the court may only determine if there is a rational nexus with the objects sought to be achieved. That is, determine the relationship of the means to that is, determine the relationship of the means to end. Any other test, including the proportionality test, would impinge on the freedom of the executive and the legislature in enacting and implementing economic policy measures. Going any further would also dilute the well-established and oft-repeated universal position of law that courts ought not to engage in judicial review economic policy legislation in promotion of economic measures. I'll place the two judgments for Lord's consideration. One, a recent judgment where the distinction between non-classificatory discrimination and classificatory discrimination arbitrariness. I'll just place it in a few minutes. Now let me complete the reading of this. The notification dated 16/12/2016 has been conceived as a first step measure towards addressing the three evils and to lay the foundation for further scope for addressing those evils as well as achieving major milestones of larger economic transformatory and reformatory process that has been going on since the year 2014, probably even earlier. The aforesaid economic reformatory process includes the strengthening and expansion of the formal sector with the simultaneous reduction of the informal sector through the means of digitization of transaction, technology connectivity, increasing the tax base, enhancing tax compliance, lowering the cost of doing business, eliminating policy distortions, facilitating financial inclusion at the formal sector level in labor and agrarian reforms. A whole lot of them. In view of the above stated larger purpose, the legitimate aim and objective of demonetization as here. As one amongst other monetary and economic policy decisions cannot be subject to judicial review on the grounds suggested by the petitioners. May I just quickly, at this point of time, your lordship take to the cryptocurrency judgment and one second, just one second. I'll check. This is the 2020-10 SEC 274. at page 322, paragraph 70, Lordship had occasion to look into the addition to the preamble, which I read out, which I'll read out again. So after looking at the important additions in the preamble, on the right-hand side, we have those two important additions. And whereas it is essential to have a modern monetary policy framework to meet the challenge of an increasingly complex economy, and whereas the primary objective of the monetary policy is to maintain price stability while keeping in mind the objective of growth, and whereas the monetary policy framework in India will be operated by the Reserve Bank of India. And then kindly turn to para 72. Therefore, it's clear that after the amendment under 2016, the very task of operating the monetary policy framework has been conferred exclusively upon RBI. Then at paragraph 80, 85, at page 326, where the court also notices the Banking Regulation Act. The RBI Act is not the only act when the RBI derives its powers. Banking Regulation Act is also a source of power for RBI to do certain things. This can be seen from the statement of objects and reasons for the banking regulation. One of the main features of the bill, as indicated in the statement of objects, was widening the powers of RBI as to enable it to come to the aid of banking companies in times of emergency. That's another being of the RBI functions. Then kindly turn over to paragraph 117. The context of money, history, what is legal tender, etc. The court traces beautifully those history of money. And page that the 1879 definition cannot be accepted as perfect, final, and everlasting in modern times. Cross-border transactions and technological advancements have removed many shackles created by old concepts. This fact has been recognized in the dissent of so-and-so when he says, what we view as money has changed over time. Cowrie shells once were such a medium, but no longer are. Currency originally included gold, coins, and bullion. But after 34, gold could not be used as a medium of exchange. Perhaps one day employees will be paid in Bitcoin or some other type of currency. The English linguistic sense, English Oxford Dictionary has already indicated property or possessions of any kind viewed as convertible into money within definition of money and all that. Then, therefore, Breyer J. points out his dissent. So where does this duel of definitions lead us? Some seem too narrow, some seem too broad, some seem indeterminate. The result is ambiguity. He therefore concluded the stock options given to employers constitute money remuneration for the service rendered, but the majority pressed in the base that when the law was enacted, the term money was not used in expansive sense. So if you're looking at what possible sense a word can receive, given the context in which the statute wishes to operate. Then 118, the middle of that, even though it's again in the context of cryptocurrency, just after placitum B, or para 118, clause 33 of section 65B of the Finance Act, inserted by way of Finance Act, defines money to mean legal tender, check, promissory note, bill of exchange, letter of credit, so on and so on and so forth. This definition is important, for it identifies many instruments other than legal tender, which come with the definition of money. Therefore, we are at an age when not only legal tender, something which can claim to be a legal tender, how do you go about regulating it? This court answers this case in this case. I'll presently point out how the reference to proportionality was context specific and cannot be probably invoked as far as this particular case is concerned. Now, kindly pick up paragraph 137. Because the court notices what happened in the case. Your Lordship, may kindly turn to para 141 at page 359.
Para?
141. pointed out elsewhere, RBI is the sole repository of power of the management of the currency under Section 3. RBI is also vested with the sole right to issue banknotes and to issue currency notes supplied by the Government of India, and an important role to play in evolving the monetary policy of the country. By participation in the Monetary Policy Committee, which is empowered to determine the policy rate required to change the inflation target in terms of the Consumer Price Index. Therefore, anything that may pose a threat or to have an impact on the financial system of the country can be regulated or prohibited by RBI, despite the said activity not forming part of the credit system or payment system. Therefore, even if it's not part of a payment system or credit system, RBI will certainly extend its hands to deal with that. But what to say of terror financing, black money, and fake currencies? And as I said, they're all. The expression management of the currency, appearance and so on, need not necessarily be confined to the management of what is recognized in law to be currency, but also we include capable of faking or playing the role of a currency. And at page para 150 at page 363, law is well settled when RBI exercises the powers conferred upon it, both to frame policy and to issue directions for the enforcement. Such directions become supplemental to the Act itself. In PLR so-and-so, court followed the decisions in state of UP with Baburam Upadhyaya and DVK so-and-so to hold that rules made under the statute will be treated as if they were contained in the Act, and therefore they must be governed by the same principle as the statute itself. Useful reference can also be made in regard to the following observations so-and-so. When a delegate is empowered by Parliament to enact a policy and to issue direction, which have a statutory force, and when the delegate issues such guidelines having statutory force, such guidelines have got to be read as supplement to the provisions of the Banking Regulation 1949. The banking policy is initiated by RBI. Such policy cannot be said to be ultra vires the Act. At paragraph 177 at page 371, before the court turns over to the proportionality test.
Can read the next para also.
I'll come to that.
Para 151.
Para 151. In his treatise on administrative law, I go back to page 363, paragraph 151. In his treatise on administrative law, Durgadas Basu states the scope of judicial review is narrowed down when a statute confers discretionary power upon executive authority to make such rules or regulations or orders as appear to him to be necessary or expedient for carrying out the purpose of the statute or any other specified purpose. In such a case, the check of ultra vires vanishes for all practical purposes, inasmuch as the determination of the necessity or expediency is taken out of the hands of the courts, and the only ground upon which the courts may interfere is that the authority acted malafide or never applied his mind to the matter or applied an irrelevant principle in making a statutory order. I go down to your lordship's mention. So on the larger usual administrative law challenge, relevant grounds, irrelevant factors taken into account. So the petitioners want your lordships to go into the question as to whether 86.4 currency notes and the hardship that will be caused by increasing all those notes in one go. So you're not applied it mind, the relevant factor to be applied to your mind. So you must have a study how it will impact. I'll presently show that for more than a decade, governments and RBI have been looking at these three twin problems. The 1978 legislation was also addressed this question. Therefore, if the nation is called upon to address this question in very complex, dynamic, globalized situation, and where all the three factors can mask themselves, cover themselves under any facades, and escape any inquiry, and you will still say address each one of these questions by an open debate, share them with the citizens of the country, and say, tomorrow I'm going to take a decision on this. Therefore, all these three evils, which I kept on saying last time, which grin at you from somewhere in the corner where you cannot even reach. All those measures taken over a large period of time. Black money is stashed elsewhere. You can say they fail. Therefore, you should not touch them. It's like Jarasan. Unless you know how to kill Jarasan, you must cut him into pieces. If you don't cut him into pieces, Jarasan will always be alive. Therefore, it's a very hot choice. Like a choice.
Not cutting to pieces, cutting two pieces and throw it.
And throw it. Asunder. Take asunder. That's how it's happened.
It doesn't join.
Otherwise, it'll join. So we are looking at a phenomena which is a big challenge to the state, not only here, elsewhere. Paragraph 177 at page 371. The impugned circular cannot be assailed on the basis of MS guilt test for two reasons that the Mohinder Singh statement in the election matter. First is that the All India Railway Recruitment Board, so and so, this court held that MS guilt test may not always be applicable where larger public interest is involved, and that in such situation, additional grounds can be looked into for examining the validity of an order. This followed in so and so, this court clarified that there is no broad proposition that MS guilt test will not apply and the larger public interest is involved. Subsequent material in the form of facts that have taken place after the order in question is passed can always be looked at in the larger public interest in order to support an administrative order. That's why it took time to show lodges from 2016 onwards. What are the developments that have taken place? Directly or indirectly, tangible or intangible. If you want to look at this case only from the midnight of 8th of November 2016, the case is very different. The second reason why the weapon of MS Gill will get blunted in this case is that during the pendency of this case, the court passed an interim order, let's skip that. Then come to paragraph 178, where the court is getting into the proportionality test. The next argument is the impugned measure is extreme and it will not pass the test of proportionality. For the purpose of convenience, we'll take the argument together. The arguments revolving around Article 19(1)(g) will deal with the reasonableness of the restriction. For our purposes, I think it's sufficient if your lordship kindly turn to page 1, paragraph 190 at page 374. Why the court went into the question of proportionality in the context of a particular case. The court is again giving an overview of the role of RBI, paragraph 190 at page 374. But given the scheme of the RBI Act 1934 and the Banking Regulation Act 49, there were arguments appeared only to belittle the role of RBI. RBI is not just like any other statutory body, act of legislature, created with a mandate to get liberated even from the creator. That's why it's given a mandate under the preamble of the act to operate the currency and credit system of the country to its advantage and to operate the monetary policy framework in the country. Under Section 3(1), to take over the management of the currency from central government. Section 20, to undertake accept monies for account of central government, to make payments up to the amount standing to the credit of the account, and to carry out the exchange, remittance, and other banking operation, including the management of the public debt of the union. Under Section 21(1), to all the money, remittance, exchange, and banking transactions in India of the central government enters so and so. 5. Under Section 22(1), there are of Article 372, the difference between other statutory creatures and RBI is that whether statutory creatures can do and could do as will be done by the executive, the power conferred, delegated in some other statutes, can be tinkered with, amended, or even withdrawn, the power conferred and so 3.1 to take over the management of the currency in the central government cannot be taken away. Now, paragraph 190, 197. May read para 193 so that the context of 194 is understood. 193 at page 376. The next ground of attack is on the base of Article 19(1)(g). Any restriction to the freedom guaranteed in the Article 19(1)(g) should pass the test of reasonableness in terms of 19(6). Contend with the petitioner that since access to banking is equivalent of the supply of oxygen in a modern economy, the denial of such access to those who carry on a trade which is not prohibited by law is not a reasonable restriction, and that it is also extremely disproportionate. It's further contended that the right to access the banking system is actually integral to the right to carry on any trade or profession, and therefore a legislation, subordinate or otherwise, whose effect or impact severely impair the right to carry on a trade or business not prohibited by law would be violative of Article 19(1)(g). Reliance is placed in regard and decisions court in Muhammad Yasin with the Town Area Committee, where it was held the right in Article 19(1)(g) is affected. In effect and in substance, the impugn measures brought about a total stoppage of business, both in a commercial sense and from practical point of view, even though there is no prohibition in form and to Bennett Coleman Union of India. This court held that the impact, not the object of the measure, will determine whether or not a fundamental right is violated. It's further contended the strength of the decision Muhammad Farooq that the imposition of restriction on the exercise of fundamental right may be in the form of control or prohibition, and that when the exercise of a fundamental right is prohibited, the burden of proving that a total ban on the exercise of the right alone may ensure the maintenance of the general public interest lies heavily upon the state. It was held in a said decision that a law which directly infringes that the rights guaranteed in Article 19(1)(g) be upheld only if it is established that it seeks to impose reasonable restrictions in the interest of the general public, and a less drastic restriction will not ensure the interest of the general public. That's the test which ought to be applied here. The parameters laid out in Muhammad Farooq were unimpeachable. While testing the validity of a law imposing restrictions on the carrying on a business or a profession, the court must have formulated Muhammad Farooq attempt an evaluation of its direct and immediate impact upon the fundamental rights of citizens affected thereby, the larger public interest sought to be ensured in the light of the objects sought to be achieved, the necessity to restrict citizens' freedom, the inherent pernicious nature of the act prohibited, or its capacity or tendency to be harmful to the general public, and the possibility of achieving the same object by imposing a less drastic restraint. There are two questions to be addressed here, just to digress for a minute. If the government and RBI has to take a decision on addressing those three evils, then you will have to apply your mind. Look at the volume of circulation of notes of 500 and 1,000. How are we going to impose so many restrictions and hardships on the general public? Should the government or the decision-making authority keep aside all these considerations, but only look at the evils sought to be addressed, or close his mind to the evils sought to be addressed and only look at them? Therefore, the balance which have to be achieved will be the real test in a matter of this nature. To say that hardships have been completely, not, adverted to, we're probably taking it to an excessive length. The occurrence of certain series of events in the course of exchange of notes may be unfolding events of hardships. But to say that in order that we'll have a period during which people will be enabled to exchange their notes, and it will be a longer period, shorter period, and whatever consideration may come for the purpose of facilitating them, then I'm only addressing a very different, narrow issue about the whole issue of addressing the other three evils. So that's why I said you are talking about comparing the incommensurables. The two are not comparable at all. That's why in a proportionality test, I'll place before your lordships a very interesting reading from a book on critique of proportionality and balancing, which says very often in the proportionality test, incommensurables are compared. And there's always a scope for unrestrained moral reasoning, not for wrong reason. The court is always prompted to get in some moral reasoning, sometimes for good reasons. Let me read further. Paragraph 190, 197.
95, so not reading. Okay. AG, you're not reading 195.
Paragraph 197 at page 378.
Mr. Chidambara wants you to read 195 also.
I'll read it. I'll read it after I finish
He
reading.
wants to read it. You to read it. Very well.
I will read it in a context.
Okay.
Para 197. The second objection of RBI is there is no fundamental right to purchase, sell, transact, or invest in virtual currencies, and that therefore the petitioners cannot invoke Article 19(1)(g). But is contention liable to be rejected out of two reasons? That at least some of the petitioners are not claiming any right to purchase, sell, or transact in virtual currencies, but claiming a right to provide a platform for facilitating an activity of trading in virtual currencies between individuals, entities who want to buy and sell VCs, which is not yet prohibited by law. And that in any case, the impugned circular does not per se prohibit the purchase or sale of virtual currency. This is why it is contended, then accounts for the petitioner, that what is hit by the impugned circular is not the actual target. So that was one important reason why the court went into the proportionality test in this case. The object of hitting at trading in VC is to ensure that, just after Placitum C, the object of hitting at trading in VCs is to ensure consumer protection, prevention of violation of money laundering laws, curbing the menace of financing terrorism, and safeguarding of the existing monetary payment credit system from being polluted. But hitting the target directly is not within the domain of RBI, and hence the impugned circular purportedly seeks to protect only those regulated entities by ring-fencing them. In the process, it has hit VC exchanges and not the actual trading of VCs, though as a consequence, the volume of transactions in VCs is stated to have come down. People who wish to buy and sell virtual currencies can still so merely without using the medium of the VC exchange and without seeking to convert the virtual currencies into fiat currency. It is in this context, contention of revolving around 19(1)(g) has to be examined. Then at page 200 and paragraph 198, let me read that. In order to test the validity of the impugned action and the touchstone of Article 19(1)(g), you may have to understand the fundamental distinction between the purchase and sale of virtual currencies by and between two individuals or entities and the business of online exchanges that provide certain services such as the facility of buying and selling virtual currencies, the storing or securing of virtual currencies, what are known as wallets, and the conversion of virtual currencies into fiat currency and vice versa. The buying and selling of cryptocurrencies through VC exchanges can be by way of hobby or as a trade or a business. The distinction between the two is that there may or may not exist a profit motive in the former, while it would be in the later. Then then talk about the category of persons who may engage in virtual currencies. Kindly turn over to paragraph 206 at page 380. And just about that, paragraph 205, persons who have suffered a deadly blow from the impugned circular are only those running virtual exchanges, not even those who are trading in VCs. Persons trading in VCs even now have different options, some of which we have discussed above, but the VC exchanges do not appear to have found any other means of survival, if, at least as of now, if they're disconnected from the banking channel. In all cases where legislative executive action infringing the right guaranteed in Article 19(1)(g) were set at naught by this court was concerned with a ban or prohibition of an activity. The question of the prohibited banned activities having the potential to destabilize an existing system did not arise in those cases. The pleadings contain the first writ petition from so-and-so would show the three companies who are members of the Internet Mobile Association had combined total of approximately 17 lakh verified users throughout India. These companies have the combined total of approximately 1,365 crores of user funds interest. The approximate monthly transactions for just these three companies around 5,000 crores. Even according to the petitioner, the crypto asset industry is estimated to have market capitalization of approximately 430 billion US dollars globally. India is estimated to contribute in 2 to 110% based on various estimates. Admitted that the total number of investors was approximately 20 lakh and the average daily trade volume was at least 150 crores at the time when the writ petition was filed. Therefore, if a central authority like RBI on a conspectus of various factors perceives the trend as a growth of a parallel economy and sever the umbilical cord that virtual currency has with the fiat currency, the same cannot be very lightly nullified as amending Article 19(1)(g). But nevertheless, then kindly come to, then the court goes into how the targets have been wrongly picked up, and therefore the question of proportionality. Finally, at page 230, paragraph 234. In para 224, as I said, the reasons for entering into the proportionality test and the conclusions drawn. It's no doubt true that RBI has very wide powers, not only in view of the statutory scheme of the three enactments indicated earlier, but also in view of the special place and role in the economy of the country. These powers can be exercised both in form of preventive as well as curative measures. But the availability of power different the manner and extent which it can be exercised. And that's while we have recognized elsewhere in this order the power of RBI to take a preemptive action. We are testing in this part of the order the proportionality of such measure, but the determination of which RBI needs to show at least some semblance of any damage suffered by its regulated entities. But there is none. And the consistent stand of RBI is that they have not banned VCs. The government of India is unable to take a call despite several committees coming up with several proposals, including the two draft bill, both of which advocated exactly opposite positions. It's not possible for us to hold that the impune measure is proportionate. So for that's the factual matrix in which the court was persuaded to enter into a proportionate analysis. And the court is conscious of the fact that having traced the extent and sweep of the powers of RBI, it's an important role as a monetary policy, framing and executing authority. Not in all cases, the court will probably enter into this proportionality test. But it's one of those narrow circumstances when, in an economic policy measure, when not necessarily an economic policy measure, but acting, exercise your powers under the Act. Oh. This judgment I want to place the Lordship's consideration on an important distinction the court has recently drawn. Paragraph 2, that's how the question arose. The government of Tamil Nadu granted a waiver of outstanding crop loans, medium-term agriculture loans, long-term farm sector loans issued to small and marginal farmers. So-and-so was issued providing guidelines for the implementation of due so-and-so. Guidelines provide that for the classification of farmers as small and marginal, the extent of landholding is mentioned in the landholding register and loan register. At the time of sanction of the agricultural loan should be taken into consideration. As for the definition of small farmer and marginal farmer, it provides so-and-so. All that issues of fact. And sought a direction to provide loan waiver for all farmers, irrespective of the extent of land holding. The High Court allowed the writ petition holding that the exclusion of other farmers, those who hold land exceeding 5 acres from the land waiver scheme, is discriminatory and violative of Article 14. It directed the scheme be extended to all farmers, including farmers whose land holding exceeds 5 acres. The High Court is aided by the following reason to arrive at this conclusion. Courts can exercise judicial review in the realm of policy to determine if it conforms to the requirements of Article 14 of the Constitution, held by this court in Union of India, so and so, then made an electoral promise to implement the scheme he voted to power. The counter filed with the response stated that small marginal farmers constitute a class in themselves, and they require more assistance because of their meager income resources. There is no indication of the reasoning in the file. ADMK introduced the scheme after being voted to power in pursuance of election promise, without taking into consideration relevant factors warranting such a classification. The contention of the state that the objective of the scheme is to cover a maximum number of beneficiaries with a minimum outlay of funds cannot be accepted, and the overall objective of the government of the farmers classification based on the extent of holding is not intelligible. Farmers who apply for agricultural loan are not required to disclose all their land holding. Question 1. The court can exercise its powers of judicial reviews. The scheme is a policy decision of the government. The extension of the scheme only to small farmers and marginal farmers is arbitrary and violative of Article 14, and whether the scheme is under-inclusive and over-inclusive. I will not trouble your lordships with the details of this reasoning process. In paragraph 10, all those cautions are restated. The court cannot, paragraph 10, cannot interfere with the soundness and wisdom of policy on the limited grounds of compliance with the fundamental rights and other provisions of the Constitution. Also, settled courts which show a high degree of deference to matters concerning economic policy compared to other matters of civil and political rights. In Archegag, this court decided on the constitutional validity of the special bearer bond. The challenge to the statute on the principal ground is violative of Article 14. Rejecting the challenge, the Constitutional bench observed laws relating to economic activities must be used with greater latitude and deference when compared to laws relating to civil rights such as freedom of speech. Then I'll take your lordship. Then Balfour is considered. You lords kindly turn to paragraph 27 of the judgment on one of the issues posed by the court about under-inclusion and over-inclusion. Just make a note of that. That's how the court goes into the question whether the classification can be tested on this ground. In paragraph 29, the determination of whether the classification is under-inclusive is closely related to the test that is undertaken by the court while determining the relationship of the means to the end. The court follows the two-pronged test to determine if there is a violation of Article 14. The test requires the court determine if there is a national nexus with the object sought to be achieved. So and so in Rayappa held the arbitrariness of state action is sufficient to constitute a violation of Article 14. Thus, it came to be recognized that the equality doctrine is envisaged in the Constitution not only guarantees against comparative unreasonableness, but also non-comparative unreasonableness. The court in Modern Dental College, so and so, invoked the proportional test while testing the validity of the statute and ruled that sought to regulate admissions, fees, and provided reservation for postgraduate courses in private educational institutions. In Subramaniam Swamy, the court used the proportional test to determine if the offense of criminal defamation prescribed in Section 499, 500, violates the freedom of speech and expression in Section 19.1. In Puttaswamy, a 9-judge bench of the court held the right to privacy is a fundamental right. The proportional test was used in the context of determining the limits that could be imposed on the right to privacy. The Constitution then dealt with the proportional test in justice so and so, determining the Aadhaar scheme violated the right to privacy of an individual. Our courts have used the proportionality test standard to determine non-classificatory arbitrariness and have used the twin test to determine the classification is arbitrary. As long as the classification test is to be applied, proportional test will not. Okay. So the non-classification arbitrary question will come under proportionality, umbrella. Paragraph 32. While non-classification arbitrariness is tested based on the proportionality test, but the means are required to be proportional to the object, classification arbitrariness is tested in the racial nexus test, where it is sufficient if the means share a nexus with the object. The degree of proof and the test will impact the judgment of the court and whether the law is under-inclusive or over-inclusive. A statute is under-inclusive if it fails to regulate all actors who are part of the problem. It is over-inclusive if it regulates actors who are not part of a problem the statute seeks to address. The determination of under-inclusiveness and over-inclusiveness and degrees of difference depend upon relationship prong of the test. Then the nexus test, unlike the proportionality test, is not tailored to narrow down the means to find the best means to achieve the object. It's sufficient if the means have a racial nexus to the object. Therefore, if the court show a greater degree of deference to cases where the racial nexus is applied, a greater degree of deference is shown the classification because the legislature can classify based on the degrees of harm to further the principle of substantive equality, and the classification does not require mathematical precision. The Indian courts do not apply the proportionality standard to classificatory provision. So the two-judge bench articulated the proportional standard for the protective discrimination on the ground of Article 15, and Justice Malhotra held that less difference must be allowed when the classification is based on the innate and core trait of an individual. This is not the case with Delvin Reed. In the classification, the impute scheme is based neither on the grounds of Article 14 nor on the innate and core individual. It cannot be struck down on the other grounds of under-inclusion or over-inclusion. So the court shuts down this case. For our purposes, what I want to say is that in the difference between a non-classification arbitrariness, which is part of proportionality, and the classification arbitrariness will have to be very clearly kept in mind.
We'll continue at 2.
Your Worship.